All right, take your seats. We are on the record now for the 28th Circuit Court here in Wexford County, and we begin this afternoon by taking up the case of people of the state of Michigan versus EJ Allen Cisco. This is file number 21-13071-FH. Appearances from counsel, beginning with the Assistant Attorney General on the case. Thank you.
Good afternoon, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Thank you.
I'm Robert Hartzell for Mr. Cisco, who joins me to my left.
All right, and also here in the courtroom is Mr. Kevin Stapleton. He's an agent from the Michigan Department of Corrections, and we're here today for a hearing on some alleged probation violation. It was filed in this court on October 29th. It alleges a single count of the defendant failing to pay child support as required underneath the terms and conditions of his probation that was issued as a part of his sentence. What are we doing today, Mr. Hartel?
Yes, Your Honor. Although I don't doubt my clients, when it becomes an appropriate time and sentencing would give some personal statements to the reasoning behind it, he would be willing to do it in admissions today.
All right, thank you. Mr. Cisco, is that correct?
Yes, sir.
Please raise your right hand. Sir, do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You may lower your hand. Before we begin, Mr. Cisco, as I've mentioned before, you are currently charged with a single allegation of allegedly failing to pay your child support pursuant to condition 8.1 of your terms and conditions of probation. If you do plead guilty to that single count, you'll be waiving the right to have a contested hearing, to make the prosecutor prove the allegation by a preponderance of the evidence, to question and cross-examine any witnesses presented against you, to present witness evidence or testimony if you chose, as well as the right to remain silent and the right to not have silence used against you. Do you understand that?
Yes, sir.
Additionally, if you're found to be guilty of violating your probation, you will be resentenced on your original offense. In this case, you originally were convicted of failing to pay child support, and part of that sentence was you were given a 48-day jail sentence with 18 days of credit, and placed upon was it a period of probation? Hold on. Where is it at? Oh, wait, I'm sorry. That was after that makes sense, because I wondered why I had 48 days. That was after the other probation violation, because there was one back in April. That makes this a second technical. Am I correct, Mr.
Yes,
Stapleton?
correct.
So that says a second technical violation. The court is limited to a sliding scale of 15 days for one, which has already occurred, and up to 30 days. Yes, and up to 30 days for this one, because this would be a second. Do you understand?
Yes.
All right, one moment. We're also not here for a delay, obviously, because that would have been 2021. That's well past that. So otherwise, if you plead guilty, you'll be waiving those rights that I talked about for hearing, and you'll be resentenced on your original offense. Do you understand?
Yes.
Has anyone made any promises, threats, or inducements to force or compel you to plead guilty to the single count?
No.
And has anyone made any promises to you as to exactly what the sentence would be in this court?
No.
Thank you. All right, thank you. All right, Mr. Cisco, as to that single count on the request and summons for a probation violation, how do you plead?
Guilty.
Before the court can accept that plea, first I take judicial notice of the terms and conditions of probation that were issued in this court by me, and then subsequently acknowledged by you. 1 second. Those conditions were signed by me on October 31st of 2022 and acknowledged by you on December 7th of the same year. Is it true, sir, you have not been paying on your child support?
Yes, sir.
And it looks like the last time you made a payment, it was back on March of 2024. Is that correct?
Yes, sir.
And so Ms. Williams, do you believe that he has provided a factual basis, support a finding of guilt?
Yes, Your Honor.
Are you aware of any other promises, threats, or inducements?
No, Your Honor.
Do you believe the court should comply with Michigan Court Order 6.445?
Yes, I do.
Mr. Hartel, do you agree with all three?
I do, Your Honor.
The court agrees and finds the defendant's pleas today are made freely, knowingly, and voluntarily. The court further finds the testimony provided under oath on the record, in addition to the judicial notice taken of the terms and conditions, satisfy the elements to support a finding of guilt to the single count of violating probation. Therefore, the defendant is found guilty of that single count. All right, we can proceed to sentencing now, Mr. Stapleton.
Yes.
All right, any objection to that, Mr. Hartel?
None, Your Honor.
Any objection to that, Ms. Williams?
No, Your Honor.
Back to you, Mr. Stapleton.
Thank you, Your Honor. The defendant was originally given a delay of sentence for this case and was unable to comply with the terms of the delay of sentence and was sentenced to a 3-year probation term. The original sentence was 18 days jail with 18 days credit. Since then, back about 8 months ago, almost 9 months ago, we submitted a violation for failure to pay, basically the same dates as Your Honor stated, March 2024, that he has failed to pay child support. He has since made 0 payments. At that violation, he was given 48 days jail with 18 days credit, which is roughly 30 days is what he served. So it's a very difficult case. The defendant just had back surgery, has been not able to work. He'll be able to tell you more about that himself.
All right.
I think I'm not asking for any additional jail, as I don't believe that'll solve anything. I think at least, the very least, he should be given an unsuccessful discharge of this probation. And the obligations are obviously preserved.
All right. Thank you. Mr. Hartel, I'm going to turn to you just a moment. I'll hear from you, the defense last. Ms. Williams, anything to provide?
No, Your Honor. I listened to the testimony of the probation officer, and I would agree with that. My system reflects those lack of payments, and I would agree with him and would ask that you adopt the recommendation of the probation department today. Thank you.
Thank you. Mr. Stapleton, was there another? Hold on. Were there any other probation violations? Was there an informal one?
You know, that brings to question myself here.
Yeah. Because I don't know how I gave 48 days. There had to have been another informal violation.
Yes, you're right.
All right.
Give me just a moment here. Yes, there was,
That the one on March 13th?
yeah, March 13th of
Yeah.
23.
All right, got me. Whew. I thought maybe I made a mistake when I gave the 30 days. Now I understand why I did that. All right, thank you very much, Ms. Williams. Mr. Hartel, ball's in your court. Allocution.
Thank you, Your Honor. Largely, I will just ask the court to adopt the same recommendation asked by the other parties here today. When I met with my client earlier today, that is what he was asking me to ask of the courts. And we know there's a difference between just an explanation and a legal excuse. I know he's going to go into a little bit more detail, which I think it'll be more humanized if he does, but the summarized version is medical. He is trying to get on Social Security. It's a long road. I'm sure Your Honor is familiar with how long that can take for some people to get on and things of that nature. He does realize that even if the court, I don't want to say merely, if the court did discharge him from probation, which we would ask the courts to do, even if the court did not give him any additional jail, which again, we'd ask the court not to do, he's still going to be required to make these payments. It's not going to go away. There is threat of being rearrested, even if he's not on probation, and he's consciously aware of that. I've also advised him how if there is a mark on future PSIs of not completing probation successfully, how that can impact him if he's ever back before any court. He is aware of that. Thank you, Your Honor.
Thank you. Mr. Ziska, anything further?
What's that?
Anything further?
You have anything you want the judge to know?
I'm pretty much disabled and I can't work. I have a bunch of doctor's notes here that state why.
I got it. All right. The court sentences the defendant as follows. All fines and costs of restitution are preserved. Probation is terminated without improvement. The court sentences the defendant to the original 48 days with the 18 days of credit. Let me explain how this really isn't beneficial. Number one, the court cannot give jail when somebody fails to pay fines and costs of probation unless there's a proof that the defendant has the ability to afford to pay and yet chooses not to. The situation here is if this comes back up and there are additional charges, while I can't give jail now because you don't have the ability to pay, next time, if there is a next time, you're likely to still score an intermediate sanction cell, but because you have violated probation, I could use that for reasonable grounds next time, and I can give more jail. So it's not a great system. It doesn't make a lot of sense to me, but it's not my job to make it make sense or to do anything else. But I'll just say, I want you to realize next time, if it comes up, if you get another charge for it, you come here before the court, the likelihood of getting jailed the next time would be based upon reasonable grounds. So just keep that in mind. Find a way to make sure you're starting to make payments. I'm sorry, anything else that I missed, Mr. Stapleton?
No, Your Honor, thank you.
Anything further from the people, Ms. Williams?
No, Your Honor.
Mr. Hartel is going to bring to you, Mr. Zivka, 2 copies of one document that he's going to obtain from the court clerk. You're going to place your initials on one copy. Doing so neither elects nor waives your right to merely acknowledges receipt to your copy of the document. This document tells you that you have the right to appeal the conviction and sentence in your case. That is typically done by filing a claim of right to appeal. However, based upon the plea in this case, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of the copy that you're taking with you and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. This also will conclude this case. Any questions?
No, sir.
Thank you very much. We're adjourned. Mr.
Honor.
Oh, wait,
Did you say 18 days credit or 48 days of credit?
48 days. Thank you very much, Madam Clerk. Well, probably had 5 days of good conduct time credit. Well, we'll just say 48 days.
Okay.
Thank you. Let's not dawdle. Thank you.